Is an employee victim of a workplace shooting entitled to workers' compensation benefits, even if there's no proof of animosity on the part of the attacker? To find out, you have to read Timperio versus Bronx-Lebanon Hospital, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Timperio versus Bronx-Lebanon Hospital and the Workers' Compensation Board. The citation for this case is 2024 New York Slip Opinion 02723, published by the New York Court of Appeals on May 16th of 2024. The issue in this case is whether an incident of workplace violence, a mass shooting incident, still allows for the presumption that the injuries resulted from the employer, from the employment situation and are therefore compensable under the workers' compensation scheme. To appreciate the context of this case, I think what's helpful to know is that under Workers' Compensation Law 21, sub 1, it states that when an injury arises in the course of a worker's employment, it is presumed to arise out of the worker's employment and is therefore compensable under workers' compensation, absent substantial evidence to the contrary. Okay? And the workers' compensation scheme is designed to make sure that employees who are injured in a work environment have access to compensation separate and apart, even if the employer is insolvent, has no money to pay in a tort, in a civil negligence kind of a case. But the trade-off here is that there's an exclusivity of remedy. If you get workers' compensation benefits, you then cannot sue your employer in negligence or for tort remedies. And that's found under Workers' Compensation Law 11. It says the liability of an employer prescribed by the last preceding section shall be exclusive and in place of any other liability whatsoever. So what are the facts of this case? The facts are that in 2017, right before 2017, there was a doctor named Henry Bello, who was a doctor at Bronx-Lebanon Hospital, who was fired from Bronx-Lebanon Hospital. In June 30th of 2017, Mr. Bello came back to Bronx-Lebanon Hospital, entered with a doctor's coat, a white doctor's coat, and hidden in his coat or underneath his coat was a loaded AR-15 rifle. He had ammunition magazines and a juice container full of gasoline. He went to the 16th floor where Justin Timperio, who's our claimant here, was working as a first-year resident doctor at the hospital. Now, Timperio had never met Bello before. They'd never seen each other or had any animosity or any contact whatsoever, as far as we know. Bello opened fire with the rifle, killing one doctor and injuring 5 other people of the medical staff, including Timperio. Bello ultimately barricaded himself in a room, set himself on fire, and killed himself. Timperio was injured, and the hospital then contacted the Workers' Compensation Board and filed a claim saying these people are injured, including Timperio. Meanwhile, Timperio didn't want to pursue his workers' compensation remedy and instead went to federal court and filed a lawsuit against Bronx-Lebanon Hospital and the store that sold Bello the rifle. When the hospital moved to dismiss that federal tort claim, the claim filed in federal court in Southern District, the judge in federal court denied it and stayed the action, waiting the outcome of the Workers' Compensation Board because of that exclusivity of remedy. And in September of 2020, the Workers' Compensation Law judge determined that Timperio's injuries were compensable, that he would get workers' compensation benefits. Timperio didn't want that. He wanted the federal tort claim benefits. So he sued. And the appellate division then, addressing the workers' compensation claim, said that they applied a standard where they basically said, yes, the presumption applies that if a person's injured in the course of their employment, it's presumed to arise out of employment. But here, and this is what the Appellate Division 3rd Department got wrong, ultimately, you find out, is the Appellate Division 3rd Department said, here, there's no evidence as to whether there was an animosity, whether the motivation of the attacker had any animosity or animus with respect to Timperio, and therefore the presumption does not apply. So they said that the nexus was lacking. So they said that so then at this point, the Bronx-Lebanon Hospital sued because they wanted the workers' compensation approved. It goes to the Court of Appeals, and here what they say, there's a Court of Appeals saying workplace violence, which is not uncommon. Workplace violence is not an exception to the workers' compensation scheme. A lack of evidence for motivation for the assault does not rebut the presumption. The presumption exists. If someone files a claim for an injury that occurs in the course of employment, in the workplace, that presumption applies. And it applies even if there's no motivation. It's only basically what the appellate division here did is they inverted it. They said the lack of evidence as to the motivation rebuts the presumption, and that's not the way that the law works. They said an assault that arises in the course of employment is presumed to have arisen out of the employment, absent substantial evidence that the assault was motivated by personal animosity. If you don't have that evidence of personal animosity, the presumption applies, and it's compensable under workers' compensation. And that's the case of Timperio versus Bronx-Lebanon Hospital. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.